I call Charles Cheval.
Thank you, Mr Speaker. Mr Speaker, I want to deal with a number of the points that were made by the previous speaker, because he suggested that the opposition was not opposing this bill on the basis of principle. And Mr Speaker, nothing could be further from the truth. And that member knows, because it's been Labour's position from the start, that this bill is inadequate. No, Dr Smith, it's not pure politics. Dr Smith, you're the master of that art in this House. People on this side of the House take principled positions, and I want to say exactly what those positions were. Let's start with the first principles, the principles around our international obligations. Now, no amount of asserting on the part of the National Party that this legislation is compliant with those obligations will make it so, in the face of the submissions that were received from experts who were very clear that that wasn't the case. The United Nations Convention on the Law of the Sea is absolutely clear in Article 192. Article 192 states that states parties have the obligation to protect and preserve the marine environment. Article 193 goes on to allow for the exploitation by states of their natural resources, but it's pursuant to their environmental policies and in accordance with their duty to protect and preserve the marine environment. Now, Dr Smith knows, because he introduced this legislation, and I thought it was interesting that he failed to acknowledge this in his contribution just now, that when the bill was introduced, it had a purpose section that actually pitted the environment and the economy against each other. And I said in my contribution, I think during the committee stages, that the current minister deserves some credit for modifying that purpose clause. The worst of the pitting of the two considerations against one another has been removed, but it still falls short of properly protecting New Zealand's environment, just like other important environmental legislation that we've seen introduced by this government, just like the Environmental Protection Act that was referred to by the previous speaker. An Environmental Protection Act that doesn't even include in its purpose statement a duty to protect the environment. That is the sort of commitment to the environment that we've seen from this government, and it is reinforced in this legislation. The legislation is inconsistent with our obligations under the United Nations Convention on the Law of the Sea, where the right to exploit resources is accompanied by a very clear duty to protect and preserve that precious marine environment. The international obligations section, as amended, if it passes in its current form, will mean that decision makers have no obligation whatsoever, sir, to have regard to our international obligations. And the chair of the Select Committee, who I apprehend might speak soon, conceded as much in the committee stages. She said that that was a deliberate choice urged on her by the officials. So what do our international obligations mean to the National Party? Why are we legislating in derogation of them? Why are we seeing in the House legislation that actually ignores those obligations and moreover, within the four corners of the legislation, calls for them to be ignored? This is not good practice, sir, and it's certainly not consistent with what we have told the world we will do. So the second objection that Labour raises to this legislation, and has maintained throughout, is that the regime that it will create will be much weaker than the regime that is created by the Resource Management Act and which applies on land in New Zealand. Now, Dr Smith said there are only anticipated to be 6 applications per year dealt with by the EPA under this legislation, whereas there are thousands and thousands of applications under the Resource Management Act. So why would you apply the same test? Well, there are a number of reasons, sir. First of all, everybody knows what the tests are under the Resource Management Act. The law is settled, it's clear and well understood. So no confusion will arise, no litigation risk or cost will arise from putting the same regime in place onshore and offshore. But perhaps more importantly, sir, as we saw with the Rena disaster, there's a very, very important issue here. Maybe there are only 6 applications that might be dealt with every year, But the consequence of failure, the consequence of weak conditions being set as part of a consenting process are catastrophic when they occur in the marine environment. And they cannot be allowed to occur in that environment willy-nilly. That is why tough protection is needed within the exclusive economic zone and on the continental shelf. Now, as I said, sir, the tests under the Resource Management Act are well understood. Local and regional authorities already have experience managing those activities. The EPA would be able to pick up that experience, understand it and apply it very easily if the same sort of legal tests were proposed in this legislation. But instead, we have a completely new regime. And some industry submitters made this point in the Select Committee. I read the submissions with interest. They basically said it would make sense to have a closer alignment between the two on the basis that it would give business certainty, the sort of thing that the National Party talks about but doesn't practice terribly often. Business understand how the RMA operates. The completely new set of legal tests that will be put in place under this legislation will simply mean arguments in court between lawyers for many years to come, while all the law has to be settled as to what it actually means. The bill adds new terms such as favour caution, which are not widely understood or defined. And in addition, there's a definition of adaptive management, which is completely different to that which appears in the Resource Management Act case law. So these are examples of the problems that I'm pointing to, sir, with this different regime that is being set in place. The third objection that the Labour Party has raised consistently to this legislation is that the process for issuing marine consents should be much more transparent than it is proposed to be. We're concerned there are significantly more restrictions and barriers for submitters than there are for applicants. And we are very disappointed that the bill blocks appeals to the Environment Court, the very body that has expertise in dealing with these sort of specialist objections and issues. It makes no sense to bar the jurisdiction of that court, and that is a step that we should be very, very concerned about. So the fourth objection, again advanced consistently by Labour throughout this process, has been the government's complete failure to consult or involve iwi through the process that has been invoked in getting this bill into the House. And their input into the processes that are set out in the bill will only be optional and at the discretion of the EPA. Now, we supported a submission made that the bill should be amended to include reference to Moriori and Tikane Moriori in the bill. We put up an amendment to do that, and National voted it down. We objected to the treaty clause in clause 14. The bill doesn't impose a general obligation on the Crown to give effect to the principles of the treaty. Again, we put up an amendment to fix that, but the National Party voted it down, showing its real lack of commitment to any of the treaty principles that ought to appear in the legislation. So we're also concerned that the provisions covering penalties and cost recovery for a breach of the Act are inadequate. Yes, we supported the increase in a penalty for non-natural persons to $10 million, but the other penalty levels are too low. Again, the consequences of a disaster occurring in our marine environment are catastrophic, and we ought to show that we take this seriously by a stiff penalties regime in the Act. So finally, in answer to Dr Smith's charge that this is the first piece of important environmental legislation that hasn't been treated in a bipartisan way, the process for dealing with this bill has been shambolic. The Select Committee was rushed and didn't adequately consider the issues. There was a raft of amendments required to be put up by the Minister, which were also shambolic and rushed right at the end of the process. Those changes are significant and haven't been subject to proper scrutiny and consideration because they were put forward after the Select Committee process ended. So this is not the way to legislate on such an important matter, and these are the principled reasons why the Labour Party will not support this shambles of a bill.
I call Gareth Hughes.
Kia ora, Mr Speaker. Ngā mihi nui kia koutou. Kia ora. I rise to take a call.